The special appeal has arisen from a judgment and order of the learned single judge of this court dated 17 November 2014, while allowing the writ petition under Article 226 of the Constitution. The learned single judge set aside a order dated 16 June 2014 issued by the commandant of the 4th Battalion of the PSC at Allahabad dismissing the respondent from service under Rule 4 of the Uttar Pradesh Police Officers of the Subordinate Ranks Rules 19,911. The punishment was imposed upon the respondent after a regular departmental inquiry into a charge of misconduct. The basis on which the learned single judge has allowed the writ petition is that the respondent, being a Group D employee in the police department, would not, in the view of the learned single judge, be governed by the rule of 1991 applicable to police officers of the subordinate ranks, and that the disciplinary proceeding would be governed by the rule framed by the governor under Article 309 of the Constitution, namely the Uttar Pradesh Government Servant Rule 19,992. The respondent was appointed on the post of a peon, which is a Group D post under the Dying in Harness Rules 1974 on 20 May 2010. On 5th June 2013, a charge sheet was issued to him under Rule 14 first of the Rule of 1991 on the ground of continuous absence with effect from 21st November 2011. The respondent submitted his reply on 22 June 2013 and 25th June 2013. A disciplinary inquiry was initiated, in the course of which the inquiry officer submitted his report on 15th March 2014. Thereafter, a notice to show cause was issued by the commandant of the 4th Battalion of the PSC on 16th April 2014, calling upon him to show cause as to why he should not be dismissed from service under Rule 14 first A of the Rule of 1991. The respondent submitted his reply to the notice to show cause on 4th May 2014. An order of dismissal was passed on 16 June 2014. The respondent challenged the order in writ proceeding under Article 226 of the Constitution. The learned single judge allowed the petition on the ground that the service of the respondent were governed not by the rule of 1991 but by the rule of 1999 applicable to the government servant. In taking his view, the learned single judge relied upon a decision of a division bench of this court in Krishna Murari versus State of UP and other three decided on 10 April 2012. While allowing the writ petition and setting aside the order of dismissal, the learned single judge granted liberty to the appellants to proceed with the departmental proceeding against the respondent under the rule of 1999 from the stage of the issuance of the charge sheet. A direction was issued to restore the respondent to the status he was occupying when the charge sheet was served, together with consensual benefits including reinstatement. The issue which has been raised before the court essentially turn upon the interpretation of the rules which has been framed by the governor under Article 309 of the Constitution on the one hand and the rule framed under Police Act 18,614 on the other hand, which are applicable to members of the police force. Before we proceed to consider the two sets of rules, a brief reference to the provisions of the Police Act would be in order. Stop.